I'm Cynthia Rowland, and this is episode 104 of EO Radio Show. This week's episode is a refresh of episode 57, released in October of 2022. That addressed the implications of the Corporate Transparency Act for nonprofit organizations, especially those with complex corporate structures that involve business enterprises with outside for-profit investors. Most listeners are probably aware that Congress acted in 2021 to establish a sweeping and perpetual dragnet to aid in the policing of domestic money laundering by passing the Corporate Transparency Act, which went into effect on January 1, 2024. The act directs the United States Treasury Department's Financial Crimes Enforcement Network, known by the acronym FinCEN, to establish and maintain a national registry of beneficial owners of every legal entity formed or registered in the United States, with certain exceptions. These entities are referred to as reporting companies. The CTA, the acronym for Corporate Transparency Act, requires reporting companies to make initial and updated disclosures of information relating to the individuals who beneficially own and control the reporting company. In episode 57, my partner Greg Lasaint joined me to give us an outline of the CTA provisions and walk us through the Farella, Braun & Martel Corporate Transparency Act Guide, which may help you determine whether an entity in your organization is indeed a reporting company and subject to the disclosure requirements of the CTA. One important update to note. At the time we recorded episode 57, there was discussion about the original filing deadline for new organizations formed in 2024. There was going to be a 30-day window in 2024 to make any filings for a newly formed company. And Greg noted at the time that there were proposals to extend that to 90 days, which is exactly what happened. So, as you listen to the refresh, note that the deadline for new organizations formed in 2024 is in fact 90 days, not the original 30. But starting January 1, 2025, the filing deadline for organizations reverts to 30 days for the new organizations formed in 2025 and thereafter. But most importantly, for all reporting companies that were formed prior to 2024, their deadline for filing with FinCEN is January 1, 2025. So that is right around the corner. This refresh will provide basic information to set listeners on the right track for determining which entities are reporting companies and which are exempt. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. I'm pleased to be joined today by my colleague Greg Lasaint, a corporate transactional attorney at Farella, Braun & Martel. Greg has extensive experience advising founders, entrepreneurs, operating companies, private funds, lenders, investors, and multi-generational businesses in complex transactions, corporate governance matters, and succession planning. He prioritizes thoughtful risk assessment, focused advice, careful drafting, collaboration, and targeted negotiation to help his clients navigate uncertainty and maximize transactional value. Greg's practice spans multiple disciplines and industries, and his clients call on him to solve common as well as unique business and legal issues thoroughly and efficiently. Greg is co-chair of Farella, Braun & Martel's Private Equity and Venture Capital Initiative, and he's a member of Farella's Professional Standards Committee. Welcome to the show, Greg. Thanks so much for joining me.
Thank you, Cynthia.
Let's start at the beginning. When was this act enacted, and when does it become effective?
The Corporate Transparency Act was passed as part of the National Defense Authorization Act for fiscal year 2021, which was adopted as federal law on January 1st, 2021. This portion of the National Defense Authorization Act for that year specifically directed the Secretary of the Treasury to adopt regulations that were consistent with the act and establish essentially the procedures and the mechanisms by which required beneficial ownership information would be collected by the Secretary of Treasury. On September 30th, 2022, FinCEN, which is overseen by the Secretary of Treasury, published its final rules governing the implementation of the act, and those rules take effect on January 1st, 2024.
Okay, so kind of right around the corner. Since we're recording in early October, I think this will drop sometime mid-October. It seems like the reporting companies are going to need to get on top of in the next couple of months. Walk us through the policy behind the act. What's the objective of the law?
Sure. So the name of this law is actually appropriate for what it's trying to accomplish. So as things currently stand, you can form a legal entity in most jurisdictions in the United States without any requirement to disclose any information regarding the beneficial owners. And that's both people who own the entity and people who control it. There are limited disclosures that are required by secretaries of state, but again, this is a federal statute, so this is going to cover everything throughout the United States and its territories. Also, banks will often request beneficial ownership information if an entity is opening a bank account, but that information may only relate to the persons who manage or control the entity, and that information is not accessible to law enforcement agencies without going through a formal evidentiary process. The objective of the law is to collect beneficial ownership information from those types of legal entities that are most likely to be used in money laundering or other malign behavior. Specifically, the Act states that the collection of beneficial ownership information is needed to protect vital U.S. national security interests, protect interstate and foreign commerce, and to better enable critical national security, intelligence, and law enforcement efforts to counter money laundering, the financing of terrorism, and other illicit activity, and to also bring the U.S. into compliance with international money laundering and countering the financing of terrorism standards.
Okay, so that's a pretty important goal. That all makes sense to me, that this might be a useful tool. What entities need to report and how will they do that?
The law initially has two broad categories of entities that need to report beneficial ownership information. That's domestic reporting companies and foreign reporting companies. And this includes essentially every corporation, LLC, or other entity created by filing any paperwork with a Secretary of State or similar office holder for a tribal or territorial jurisdiction. And then as well as similar foreign entities that are registered to do business within the United States and its territories. However, the law does provide 23 exemptions for entities that are less likely to be used for money laundering. These include large operating companies, publicly traded companies, banks, public utilities, and other entities that are usually subject to other regulations where they're not as likely to be involved in money laundering. And the way that the reporting works is that FinCEN has set up a dedicated website. It's not yet available, and it's not going to accept reports prior to January 1st, 2024. But once the reporting date comes around, this website will presumably be opened and reporting companies will enter the information that's required to be reported directly onto this website.
Okay, so another fill-in form. Sounds great. I'm so excited to see that. So what is required to be disclosed? I gather there's an initial report and then it gets updated. What goes into the initial report? So what do they have to be ready with on January 1, 2024?
So the reporting company needs to provide its basic information, including its name, any DBAs and trade names, its complete current business address, its jurisdiction of formation or registration if it's a foreign reporting company, and its IRS taxpayer identification number. But most importantly, the reporting company must provide information on each of its beneficial owners. And beneficial owners, just to highlight this here, this is a statutory definition. It's specific to the Corporate Transparency Act. I'll talk a little bit about who gets picked up in that definition. But for beneficial owners, the company needs to report their full legal name, their date of birth, complete residential address, and a unique identifying number from a non-expired passport, state ID, or driver's license, and an image of that document. Now, remember, in beneficial owners, this is going to be individuals, so not entities. So again, transparency, this is looking through all of the corporate layers here. And then also, if you're a reporting company formed on or after January 1st, 2024, you will also need to provide similar information for the individuals who are responsible for forming the entity. And that would be the people at the corporation service that you're using to actually make the filing with the Secretary of State. It can involve the attorneys if you're using a law firm to form the entity, and it can involve any individual who is involved directly or indirectly in making that filing to form the entity.
Okay, so that's a lot of information. I noticed you said residential address. So this information, maybe we get to this later, but seems top of mind now. Is this public? Is this made publicly available?
No. So it's basically a database that's maintained by the Secretary of Treasury. It's not supposed to be public access, although there are some jurisdictions now that are creating, or at least considering creating, registries that have public access. But this one specifically is just supposed to be used for law enforcement purposes. And so there are several federal agencies that will have general access to this database. So anything under the Secretary of Treasury, so the IRS, FinCEN will obviously have access to this. And then there are ways in which state jurisdictions, state police, other agencies that are involved in law enforcement can apply to see this information if it relates to some type of investigation that they're conducting. And then there's also, it's designed to have a mechanism also for banks to ultimately be able to use this to do their KYC diligence for customers that are, moving funds through their institutions.
Okay, so this is a big change from the current regime. But I do see there are a lot of exemptions. As you mentioned earlier, 23 different categories. Can you talk about the significant exemptions from the Act's reporting requirements? We don't necessarily need to go through all of them. Just tell us about how to organize our thinking about the types of entities that are likely to qualify for an exemption or those that are unlikely to qualify.
Yeah, so let's start with who, at least I think, is unlikely to qualify for this. So holding companies, unless it's a registered publicly traded company, operating companies that don't qualify for there's a large operating company exemption, joint ventures, non-wholly owned subsidiaries, exempt private fund advisors. So that there is an exemption for venture capital advisors. There is an exemption for registered investment advisors. But if you operate under the exempt private fund advisor, and that's for managing a private fund or a series of funds that are less than $150 million, there's not a specific exemption for those advisors. We here at Varela, we deal with a lot of real estate investment vehicles, special purpose vehicles, anything that's really a conduit of simply moving money or holding securities. Anything that looks like it could possibly be used for money laundering is likely not going to be exempt. So the exemptions are set up really to cover entities that have a very low risk of being used for money laundering or that are, highly regulated under other statutes and regimes. So for instance, large operating companies, that's if you employ more than 20 full-time employees in the United States, you have an operating presence at a physical office in the United States, and you filed a federal tax income or information return in the United States for the previous year, demonstrating more than 5 million in gross receipts or sales.
Yeah, so that's the kind of, that big operating business is going to be exempt. And the ones that are not exempt, like you said, are the smaller number of employees used for purposes that are not, like you said, for moving money into or out of investment vehicles, things like that, are going to be reporting companies.
That's right. And there are a ton of those entities. We deal with them all the time here.
Yeah. And a lot of time for very valid business purposes. Just because a company is a reporting company and isn't entitled to exemption, it's not like a red flag. It just means that they have to report the beneficial owners.
Yeah, the way I think about this statute, honestly, is similar to a drunk driving checkpoint, basically, where you're stopping every car. Even though, most of the cars are not violating the law, everyone has to stop and the police do the checkpoint. And it only works if everyone is subject to this type of search here. Yeah, but most companies are likely not engaged in money laundering, but it does pick up a very broad range of companies.
Thinking about our focus here today, the EO radio show, we're talking about exempt organizations by and large. I see there are clear exemptions for organizations described in 501c, which includes what we all know, 501c3s, but also there's actually, I think, 25 501c subsections. So it includes things like social clubs, social welfare organizations, unions, business associations, and their controlled subsidiaries. All those are going to be described in 501c. So that seems like a pretty clear exemption. But then there's this interesting exemption for an entity assisting a tax-exempt entity. Do you have any insight on what that means, what that exemption is intended to cover?
Yeah, this is an interesting exemption. And if you look at the commentary to the rules, that commentary suggests that there was some debate around the effectiveness of this exemption. And And I think you've raised the point to me separately about how this looks like it could be used as a way to potentially circumvent this. But, notably, FinCEN had no estimate for how many of these entities actually exist. And the exemption would seem to pick up private foundations that are established exclusively to provide financial assistance or to hold governance rights over any tax-exempt entity. And I think the sort of operative word here is exclusively. This has to be the only thing that this entity is doing. And so I think that's going to generally create a fairly bright line for entities to know whether they're covered by this exemption or not.
So this exemption for an entity assisting a tax-exempt entity is probably going to be pretty narrow for a business enterprise that's formed to assist or control a tax-exempt entity. And like we said, there is a clear exemption for organizations described in 501c. Moving on to the definition of beneficial owner. I think this is the part that confused me the most at first as I read it. Nonprofits generally do not have beneficial owners. So if a nonprofit, for some reason, has a connection to a reporting entity, the Transparency Act doesn't extend through the nonprofit to its owners because it doesn't have actual owners. But I gather beneficial owner doesn't mean what it sounds like. If you don't have a beneficial owner, a nonprofit can still have an executive that is required to disclose. And now that I've confused everybody, can you walk us through the definition and how the reporting operates at the reporting company level to see when and how the Act might nevertheless require disclosure of persons involved with a nonprofit that owns an interest in a reporting company?
Yeah, so I think as far as in the nonprofit world and what you're dealing with, you might have a nonprofit that has an interest in a reporting company. And that nonprofit, although it's exempt itself, because it has that interest in a reporting company, the individuals who are, managing that nonprofit and involved in the management of the reporting company, under the Act, it's called substantial control. Those individuals might still be picked up and be considered beneficial owners of that reporting company. And so beneficial ownership under the statute, there's two different tests for it. One is ownership. So if you own 25% or more of a reporting company, you are considered a beneficial owner. But the other part of the definition is substantial control. And that says if you're an individual who exercises substantial control over a reporting company, you are also a beneficial owner, even though you don't own anything. And so where I think this really plays into your world is, again, what I said, where people are involved with reporting companies directly as part of their employment or their operations at the nonprofit. And now those individuals are considered beneficial owners of that reporting company because they have met the test for substantial control.
Okay, so most 501c organizations, if they have investments in business enterprises, if it's marketable securities or big companies, a typical investment portfolio, they're going to have such a small minority interest and or the business enterprise itself is exempt. So for most nonprofits, this is never going to come into play because they're not going to have a relationship to a reporting company. It's only those, I shouldn't say it's only, but an area where I would definitely want to think about it is if we have a 501c organization that has effective control over some business enterprise, regardless of the percentage ownership, we'll need to think through whether a person at our enterprise actually has effective control over the reporting company. Maybe you would have a better way to say it.
No, I think, an example that I've dealt with personally was I helped establish a for-profit limited liability company for individuals who are working for a nonprofit. And they separately had a fiscal sponsor, which basically had control over the funds that were directed towards the nonprofit side of that. But because that fiscal sponsor may have been tangentially connected to the formation of the for-profit entity, I could see in that instance, at least, the need to do an analysis as to whether or not anyone at that fiscal sponsor would really be considered as having substantial control of the company, which would not have met any of the exemptions. It's one of these rules now where you really have to think about this substantive control. And if your nonprofit is involved in any entity that is a reporting company, it's worthwhile to go through the examples and the analysis to determine whether or not any of the individuals at your organization might actually be considered beneficial owners under the language of the statute.
Yeah. So I think the way I think of it right now, as we step into this regime and try to understand it, there's a relatively modern trend in nonprofits to set up investment entities to raise capital, to invest in cutting edge climate technology or healthcare initiatives, or operate related businesses that support an exempt organization, things like that. If the nonprofit itself is a manager of an LLC and the nonprofit's board has control over the LLC, that's not a particular individual. Correct me if I'm wrong, it's only if that management entity that the nonprofit owns or has a substantial interest in, if that entity is essentially controlled by a single executive or a single board member or a single designator at the 501c, that seems to me a red flag to walk through the analysis carefully and see if our individual is going to need to give their information to the owned entity, which is a reporting company.
That's correct. I might expand that a little bit because there is no limit on the number of beneficial owners. And so it might not be a single individual. It might be two individuals together who are effectively controlling that reporting company. So you wouldn't want to limit yourself and just say, oh, there's one single individual who might be a beneficial owner here. It could be more than that. But you are correct, I think, in that analysis.
All right. So I think we've covered this pretty well in terms of red flags for when we need to really drill down in our analysis. So, Greg, it sounds like there are some things we don't know yet about how this act will play out, how the defined terms will be interpreted. But in light of this uncertainty and potential implications to the persons in control of nonprofit organizations that have controlling management or equity interests in reporting companies, what's the best approach as we watch the implementation of this act? I mean, how do we think about this as 2024 opens?
Sure. So I think the regulation is very clear in many instances. There are a lot of bright lines here. 25% ownership is pretty clear. A lot of the exemptions are very clear as to what that's going to pick up. But the issue of substantial control will be something that beneficial owners and reporting companies may have differing opinions on. And there are various tests to determine whether there is substantial control. They've done a fairly good job of giving the examples where this might appear, but I think there are still some places where it could be a gray area for a certain individual. I could see an instance where reporting companies may want to over-report, and beneficial owners will likely want to be left out of the registry if possible, because this is personal information that's being uploaded to a federal database. And despite being non-public, data breaches happen. Whatever issues that might entail giving this information over to the government, the litany of possibilities, right? But I think in thinking about this, I take the Charlie Munger approach here of avoiding catastrophe in the first instance. So don't do anything that would send you to jail, basically. So I think that's a good way to start. And in this case, because violating the act, there's potential prison time, there's potential thousands of dollars in fines. And so here the act, it makes it unlawful for any person to willfully provide or attempt to provide false or fraudulent beneficial ownership information to FinCEN, or to willfully fail to report complete or updated beneficial ownership information to FinCEN. And so for beneficial owners, this means not lying to the reporting company who asks for your information, and not lying to FinCEN if you report your information directly to FinCEN. And for reporting companies, it means if you are a senior officer, if you are someone who's responsible for the reporting for this company and you willfully fail to provide the required information, you are technically in violation of the act. So my suggestion for reporting companies is that they establish internal operations in order to collect and verify the personal information for their beneficial owners, and that they make it the actual duty of a senior officer to file these reports with FinCEN. These reports need to be certified by the person who's filing them that they're true and correct and complete. And so that's only information that someone who is in a senior position of management at the company is really going to be able to determine, and they're going to have to look at the beneficial ownership information that's given to them from their beneficial owners and declare to FinCEN that everything is true and complete. But I think there are over 30 million entities, I think, that the IRS and FinCEN have estimated are going to be picked up by this.
Wow.
And so, and they've already, there was going to be a 30-day window in 2024 to make any filings for a new company that's formed. They're now proposed to extend that to 90 days. So there's already some murmuring about people being able to do this, having enough time to really analyze the statute, determine who their beneficial owners are, and make the correct filings. I think we're going to see different companies take different approaches here. There are different interpretive lenses to substantial control, although I think the regulation is fairly clear. And I think in most cases, it's going to be clear to a lot of reporting companies who their beneficial owners are. I think what people want to avoid is burying their head in the sand, know when the filings are required to be submitted. So in the first instance, if you've created an entity prior to January 1st of 2024, you have actually an entire year to make your initial report. So you have until January 1st, 2025 to make that first report. So get your information in order, make sure you're not intentionally misrepresenting anything to FinCEN or the government, and get your initial report submitted prior to the end of 2024. And then, like I said, going forward, it'll be 30 days after an entity is formed, but they are considering right now, if you form an entity just in the calendar year 2024, you might have 90 days to make that filing.
And then there's also, you have to update the form if the beneficial ownership changes.
That's right. And so this is really kind of an interesting point here. And again, another reason why you want to establish internal operations that handle this. The regulation is very clear that if any beneficial ownership information changes, and that would include the residential address of one of your beneficial owners, if that happens, the reporting company actually has an obligation to report that change because the beneficial ownership information changed. Basically, that creates a burden for the company to know what's going on with their beneficial owners all the time. And there's nothing comparable to that right now, I think, for most companies that I deal with. And so establishing that internal reporting control is really necessary. There is one way to basically shift the burden of that change onto your beneficial owners, but that requires that beneficial owner essentially to get what's called a FinCEN identifier. So they'll go to the FinCEN website, they'll register as a beneficial owner, they'll put their name, residential address, their unique identifying number, and their document image into FinCEN, and then they'll get a specific FinCEN identifier. And then when the reporting company needs to make their filing with FinCEN, their initial report, they will just give that FinCEN identifier. And so that shifts the burden of changing beneficial ownership information for residential address, things like that, that shifts that to the beneficial owner itself. So that's something that I think reporting companies will really want to consider, whether they're going to require their beneficial owners to get those FinCEN identifiers just as a way of alleviating that burden of needing to be aware of your beneficial owners. But separately from that, anytime you're issuing stock, anytime a membership interest is sold between one investor and another, anytime the ownership is actually changing hands, the reporting company is going to need to remember that it might have to update its beneficial owner reports.
Wow. So there's just a lot here. Any final words of wisdom for nonprofits? And also talk a little bit about the Corporate Transparency Act guide that Farella has put together. Where our listeners find that? Any final words of wisdom you might have?
Yeah, sure. So we put together a guide that covers the regulations, and that's really designed to be very user-friendly and guide people through the exemptions and go through these tests of substantial control, 25% ownership interest. So that's available at fbm.com. I know if you go to my biography on that and go to publications, it's up there. I think it's circulating around LinkedIn at this point. But if you go to our website, if you search Corporate Transparency Act, you'll find that guide in our article. So I think that's very useful. It's about a 15-page guide. It has diagrams and ways of working through the regulation to make sure you understand how it's going to apply.
Yeah, it's a terrific guide. And we'll put links to that in the show notes and other resources for the Corporate Transparency Act. And maybe we'll talk again in a year's time, Greg, and talk through what has become known and what's still unknown. I'm just sure this is going to have a whole lot of evolution in 2024 and maybe 2025. There's a lot to unpack in this new set of regs.
That's right. And we'll have updates as more guidance comes out, as things change. Like I said, there was a proposed extension from 30 to 90 days on the time to file if you form an entity in 2024. And I think companies are going to be figuring this out, and we'll be advising companies on how to set up their operating systems. And that's going to be unique for each reporting company. as we go through this first year of reporting, I think we are going to learn a little bit. We'll see how this is actually going to function and work, and our thinking might evolve a little bit on how to handle this. But I do think the regulations are pretty clear. It's good to get familiar with them right now and be prepared for 2024 and know how this is going to be handled, because it is coming here. It is a sea change. It's very different. There's nothing comparable to it right now in U.S. corporate law. Hopefully we can help people really get familiar with the regulations and complete their obligations in a way that's not burdensome for them and keeps them out of trouble.
Oh, thanks, Greg. This has been terrific. I so appreciate you joining me today, and I hope you'll be happy to do this again next year when we know a little bit more.
Absolutely. Thanks, Cynthia.
So that's all for this episode. Like I said, be sure to check out the show notes for links to the resources and the Corporate Transparency Act guide on the Farella, Braun & Martel website. Also, Farella, Braun & Martel now has a YouTube channel, and there are several nonprofit playlists, including the one we are building that covers good governance practices for nonprofits. So look for that link in the show notes as well. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.